Hi there, welcome back to my channel. Today let's discuss about one of the most important article in the Constitution of India, that is Article 32, which itself is a fundamental right known as right to constitutional remedy. Before we go any further, if you had not subscribed my channel, please do subscribe my channel and hit the bell icon for getting the notification of my upcoming videos too. Also, like the video if you feel that the content was good and comment the comment section about any further clarification. So without any delay, let's move on to our topic. Article 32. A mere declaration of the fundamental rights in the Constitution is meaningless, useless and worthless without providing an effective machinery for their enforcement if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental rights protected is in itself a fundamental right. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away even by the way of an amendment to the Constitution. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive and summary remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other rights like non-fundamental constitutional rights, statutory rights, customary rights and so on. Now let's look into the various provisions of Article 32. Article 32 contains the following provisions. The right to move to the Supreme Court by an appropriate proceedings for the enforcement of the fundamental rights is guaranteed. The Supreme Court shall have the power to issue directions or orders or writs for the enforcement of any fundamental right. The writs may be issued includes habeas corpus, mandamus, prohibition, etc. The Parliament can empower any other court to issue directions, orders and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include the High Courts because Article 226 has already conferred these powers on the High Courts. The right to move to the Supreme Court shall not be suspended except otherwise provided for by the Constitution. Thus, the Constitution provides that the President can suspend the right to move to any court for the enforcement of the fundamental rights during a national emergency under Article 359. Under Article 32, a person can directly move to the Supreme Court of India, and under Article 226, a person can start the proceedings in the High Court when such proceedings are available. Now, let's study about the various writs available in India for the enforcement of the fundamental rights. These writs are borrowed from the English law, where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice. The Supreme Court can issue writs only for the enforcement of the fundamental rights, whereas a High Court can issue writs not only for the enforcement of a fundamental right but also for any other purpose. The Supreme Court can issue writs against a person or a government throughout the territory of India. Now, let's study about each writ in detail. The first one is habeas corpus. It is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of the detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against the arbitrary detention. The writ of habeas corpus can be issued against both the public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful, the proceeding is for the contempt of a legislature or a court, the detention is ordered by a competent court, and finally, the detention is outside the jurisdiction of the court where the proceedings are taking place right now. The next writ is mandamus. It literally means weak command. It is the command issued by a court to a public official asking him to perform his official duties that he has failed or refused to perform. It is also issued against public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force, where the duty is discretionary and not mandatory, to enforce a contractual obligation against the President of India or to the governors of the state, against the Chief Justice of a High Court acting in judicial capacity. Next comes prohibition. It literally means to forbid. It is issued by a high court to a lower court or the tribunal to prevent the latter from exceeding its jurisdiction or usurping jurisdiction that it does not possess. Thus, unlike mandamus, that directs activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities, which means it is not available against administrative authorities, legislative bodies, and private individuals or bodies. Next important writ is certiorari, which literally means to be certified or to be informed. It is issued by a higher court to a lower court or to a tribunal, either to transfer a case pending with the latter to itself or to quash the order of the latter in a case. It is issued on the grounds of excessive jurisdiction or lack of jurisdiction or the error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could only be issued against the judicial or quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting the rights of individuals. Like prohibition, certiorari is also not available against the legislative bodies and private individuals or bodies. The fifth and last writ is quo warranto, which means by what authority or by what warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can only be issued in the case of a substantive public office of permanent character created either by a statute or by the Constitution. Unlike the other four writs, this can be sought by an interested person and not necessarily by an aggrieved person. Today, we had learned about Article 32, its various provisions, and the various types of writs that can be used by an aggrieved. I hope you all liked the video. Please do subscribe my channel and keep commenting in the comment section about the videos. Till we meet with a new topic, auf Wiedersehen.